Good afternoon, everybody. I hope everybody can hear and see me and Vivienne Sedgley in the room in Chambers, 45 Gray's Inn Square. We're expecting rather more people to join than have so far joined. So we'll take it slightly slowly at the start so as to get going, and we might do a little bit of a recap if we see that a whole load of people have joined in 10 minutes time or something of that sort. But I hope the talk can be quite helpful, and we'll do it on a kind of exchange basis, or my asking Vivienne some questions or Vivienne asking me some questions. But as far as that is concerned, we'd also welcome, of course, any involvement from you using the chat button, and we can see any questions that you are posing and we can try and deal with them. And we're going to try and avoid, if we can, too much reference to this or that particular statutory provision, because I think it's important that the general approach to compulsory purchase is in mind, because on any particular compulsory purchase case, it's always going to be necessary to get to close quarters with the statutory provisions, which of course vary slightly from circumstance to circumstance. So it may be that we move now to the first slide, the introduction, and Vivienne can just tell us a bit about what's on this slide.
So by way of background for today's talk, the Law Commission are currently reviewing the law on compulsory purchase. So in the next year or two, there may be some changes on the horizon. At the moment, they've actually only just kicked off in early 2023, around now. And obviously, as part of that research, they will be consulting with stakeholders. So if you consider yourself a stakeholder and you have some views, you'll have an opportunity to make them known soon, one would expect. We know from the Law Commission website that it's actually the Department for Levelling Up Housing and Communities that asked them to do that, to look at how to produce a faster and fairer process for compulsory purchase, which is readily accessible to all parties. And so we treated that as the background to today's talk, and it caused us to ask why there might be a reluctance to make use of compulsory purchase, and in the meantime, how problems might be mitigated.
I think that's very useful to know that that's coming along. The only cautionary note I would say is the Law Commission have started. We don't know when the Law Commission will finish, and the Law Commission isn't a body which rushes around in a mad frenzy to do its work. And more particularly, after it's done its work, if it's recommending changes which will require legislation, that will also take time. And the whole matter may, of course, be put on a back burner if we get to 2024, as I hope we will eventually get to 2024, and then the general election produces a wholly new government, which might have different views from the previous government, of whatever political colour, and not seek necessarily to move so quickly as far as this is concerned. So don't rely upon the Law Commission solving problems or doing something within a timescale you view as quick. So with that, we might go, please, to the next slide. And Vivienne, once again, you can just tell us about this.
This is just an outline of what we're going to talk about today. So we'll start just with background that I'm sure will be familiar to everybody, which is the principle of compulsory purchase and why we have it. Then we'll look a little bit at the problems that might be encountered in establishing value of a compulsory purchase order, financial viability, time and cost implications, and a particularly relevant consideration in recent years, which is the public sector equality duty.
Thank you, Vivienne. And so we can then go straight from that to the next slide, which deals with the principle of a CPO. And as is said there, it allows certain public bodies to acquire land in the public interest. And lower down on the slide, some examples are given: town and country planning, highways, housing, and then particular acts of parliament, such as the Crossrail Act of 2008, and obviously the High-Speed Train Act can be mentioned in the same breath as well. But please note, those are examples, and there are lots of circumstances, in fact, where compulsory purchase can be used by local authorities or other public bodies. Lots of authorities have got compulsory purchase powers, and some authorities have got compulsory purchase powers over a whole range of activities. And a conventional local authority will have compulsory purchase powers over far more than just those particular matters. And so, as the slide says, what compulsory purchase enables to happen is for something to take place without an individual unreasonably holding that up. In other words, an individual gives way to the general public interest. And so you prevent people holding a local authority to ransom. And so with that, I think we can probably move, Vivienne, can we, to the next slide?
So the next slide deals with the issue of establishing the value of a compulsory purchase order. And the reason why that's particularly important is that proprietary rights are, of course, very well established. Article 1 of the first protocol of the UCHR entitles somebody to peaceful enjoyment of their property. And so if you're going to interfere with those rights, there's got to be a good reason for it. And that's confirmed in particular pieces of case law. One example is the case of Chesterfield Properties.
Yes, I appeared in Chesterfield Properties. In fact, it's nothing to do with Chesterfield. It's all to do with the northeast of England. And in that case, the judge had to consider those questions of substantial public interest, and more particularly consider whether the purpose behind the CPO was necessarily going to be fulfilled, because I argued that it couldn't be shown for sure that the prospective development would happen, and therefore the CPO should not be confirmed. And the judge said no, you needed to know what was proposed, you needed to know there was a substantial public interest in it, but you didn't need to know for absolute sure that it was going to happen, because the world, of course, is full of uncertainties as to what happens next. And as the slide says, general public law principles apply, and so you've got to be sure about precise wording of the legislation and follow that. You must have a sufficient evidence base, and obviously you consider relevant factors and leave out irrelevant factors. And I just want to add something, if I may, about that first bit, the precise wording of the legislation that should be followed. Because ordinarily the legislation will say something like a local planning authority may acquire land compulsorily for planning purposes. And similar language is used in other exercises. So one's always looking for a purpose. And you should always be very, very clear about that purpose. What purpose are you seeking to achieve? And it shouldn't be a vague purpose, it should be a clear purpose, so that it can be readily understood, supported, as they're said, by a sufficient evidence base, taking into account what's relevant and leaving out of account what's irrelevant. And so I think, having said that, we can probably go to the next slide.
Yes, this is looking at the guidance produced by the relevant department, which says that a compulsory purchase order should not be confirmed by the Secretary of State unless there's a compelling case in the public interest. So obviously that isn't a statutory requirement, but nevertheless is something that would be followed as a principle. And the guidance sets out in great detail, as you'll all be familiar with, various things that the relevant acquiring authority is likely to need to show, but with particular reference to a clear idea of how it intends to use the land it is proposing to acquire, and also that all necessary resources are likely to be available to achieve that end within a reasonable timescale. We know from case law that it's not necessary for all issues to be resolved before a compulsory purchase order is confirmed. So, for example, there may be matters that are described as controversial or problematic that are outstanding, but that doesn't preclude a compulsory purchase order being made. And in the case of Gala Leisure, I think the controversial and problematic matter was the closure of a road junction, which is something apt to cause controversy anyway. As a result, although the CPO is described as a matter of last resort, you don't actually have to show that it's necessary, so you have to show that every other alternative has been pursued before recourse is made to compulsory purchase. And there are a couple of examples of that where I think in the Sainsbury's case, there was an alternative scheme being put forward for the site that wouldn't have required compulsory purchase powers to be used, but that wasn't sufficient to mean that it shouldn't be used. And in the case of Sharkey, that was a case where there were travellers on the green belt, and the relevant authority had taken various steps to try and prevent them camping on the green belt in order to preserve the green belt nature of the land. And the court said that there may still be ways that they hadn't tried, but nevertheless, in those particular circumstances, this compulsory purchase order was required.
And just before we move to the next slide, if I may, I would just like to emphasize that the most important words on that slide are the words which appear twice over, in fact, and are put in bold: a compelling case in the public interest. And I would suggest that if you are embarking upon a compulsory purchase order and seeking to pursue one, you should write up and pin up somewhere those particular words, because those are going to be the guiding principle. Because if you've got something which is a compelling case, we really need this to happen, and it's a compelling case in the public interest, you are a long way down the line to being clear about your compulsory purchase order, because the compelling case will reveal with clarity, or should reveal with clarity, the purpose, and the public interest will reveal why it is that you have to go down the route of acquiring people's land, perhaps because someone is sticking out in the middle and you've got a sore thumb, which otherwise would be present and ruin whatever is proposed, or because you've just got a multiplicity of land units which need to be acquired. But you need to have that phrase in your minds throughout the whole exercise, in my view.
The next slide is highlighting a point along the same lines, which is that you can get a compulsory purchase order even if you're not actually yet in a position to implement it. One case which abides by that principle is the case of Grafton Group and the Secretary of State. And in that case, planning permission actually was refused for a particular project, but the compulsory purchase order was nevertheless confirmed because it was thought that a more acceptable scheme was likely to be put forward. The case concerned a derelict wharf on the River Thames, and a compulsory purchase order was made under the Port of London Act, looking at bringing the relevant wharf back into active use, handling riverborne aggregates. The court said that the compulsory purchase order itself was not tied to a particular scheme of a planning nature, and therefore the fact that a particular application for planning permission had been refused did not mean that the compulsory purchase order should not be confirmed.
If I can just add to that a little bit, two things really, and that was done under legislation for the Port of London Authority, revealing the point just made that a number of bodies will have compulsory purchase powers. They will have had the compulsory purchase powers for the purpose of riverside activities and so forth. And so that was the purpose in view. They didn't quite know how they were going to get there. And so consequently, planning permission had come to be refused. But the court was saying, we think a more acceptable scheme from a planning perspective will come forward, and the purpose will be capable of being achieved. Hence, you can confirm the compulsory purchase order, because you've got a clear view as to the purpose. You've got a clear view that this is something which is of public interest, because moving material about on the River Thames is plainly in the public interest, because it's the best use of the facility of the Thames, and it serves to help all who are concerned with the river. So that case illustrates a number of points which we've touched upon.
Moving on now to a particular consideration, which might be the consideration of benefits on sites other than the land that the acquiring authority are looking at acquiring. The legislation itself may look at wider benefits rather than the land in particular that is to be acquired, and it might refer to benefits more broadly. The slide we're looking at now refers to the Town and Country Planning Act, but as Tim's already highlighted, there is a large number of different pieces of legislation that you might be looking at, and so it's always going to be important to look at the wording of the particular statute that is in question. The land that may be acquired may not, if it is the case that the land that's to be acquired is not proposed to be subject to the actual development, the guidance from the relevant department gives particular points to bear in mind for that. According to the guidance, it must be essential to the successful implementation of the scheme. So they are imposing a bar that must be exceeded if that is the particular proposal. And in an area of low housing demand, property might be removed to facilitate replacement housing elsewhere, for example, within the same neighbourhood. That's an example given within the guidance itself. Off-site benefits are, however, something that should be considered carefully. The third bullet point makes this point with reference to the Sainsbury's case that we touched on a moment ago. It should always be considered whether any benefits off-site are truly relevant to the compulsory purchase housing question. In the Sainsbury's case, they were looking at the Town and Country Planning Act, section 2261A, but they said that in that case, in order to be relevant to the powers, they had to have a real connection between the off-site benefit and the development, redevelopment or improvement of the land to be compulsorily purchased. In that case, there wasn't such a real connection, because the connection was such that if Tesco were able to develop the particular land to be acquired, then there was a greater prospect of Tesco elsewhere in the authority's locality. And the Supreme Court said that's not quite what we're getting at under the 1990 Act. So that's what leads to the fourth point, which is that if in reality the benefit is simply a way of tempting a developer to develop other land, and it's really being used as a bit of a bargaining chip, it's less likely to be relevant to the question of whether or not a compulsory purchase order should be made or confirmed.
I think, if I may say so, that the points just made underline the point about public interest, because if you've got, in a sense, too close to some prospective developer with land being acquired compulsorily for planning purposes, but it's really operating so as to facilitate the developer's ability to develop other land or something of the sort, then one's not going to be able so readily as to say, this is in the public interest. The public interest may be served by securing in the town centre a retail development so as to get shoppers back into town centres, but if it's simply a way of facilitating Tesco's or Sainsbury's or somebody to have an out-of-town store, then the public interest may well be seen to be diminished.
If we move then to financial viability, this will be relevant, of course, to whether or not there is a compelling case in the public interest, but we look at it separately because it's a consideration that's likely to be key. And indeed, if reference is made to the relevant guidance, one can see that there are various points made in relation to this, and we don't set them out in great detail given that the guidance is quite long. It's worth mentioning, though, that the financial viability may be sufficient even if it's marginal, and that's a point made in the case of Chesterfield properties. But one should keep an eye on wider implications, because the greater the uncertainty one has about the financial viability of the scheme, more compelling the other grounds for undertaking the compulsory purchase will need to be. So in other words, if you have a slight negative in that the financial viability of the scheme is marginal, you're going to be wanting to bolster it on the other side to make sure that the scale very clearly weighs in favour of granting confirming the compulsory purchase order if you're for the acquiring authority.
And I think, just adding to that, it can be in mind that the funding aspect is always important in a compulsory purchase exercise to show that you're likely to have funding that's likely to proceed. By its very nature, especially for large schemes, funding is quite difficult sometimes to predict, because you will find that you can find someone in what I would describe as the market, the City of London, who is going to come forward and say, we are in the business of funding infrastructure and can do such and such. However, you will find at the same time that such people will always put in, as you see with ordinary financial advertisements, that the market can go up and down. They don't know which it's going to be, and therefore will hedge around what they're saying with a great many caveats. And so you need to be sure about how that is going to be put forward and how that's going to be presented if you're doing with a large bit of infrastructure and you want to be able to show that funding is likely to be available. I had this vividly when promoting a new bridge over the Mersey, which was going to be financed by tolls to be charged on the vehicles. But first of all, you had to get the bridge constructed, which was going to cost many millions of pounds. And then you had to get someone to agree to finance the bridge in exchange for the tolls, which were going to be made over to the person who built the bridge. And that requires quite a lot of conjectures to be in place, and you need to be clear as to how that's all going to work, and you can't leave any or too many loose ends. So it's important funding, and definitely necessary to get clear in your minds and at an inquiry, particularly if you've got objections as to how this is going to be done.
Following on from that, this slide looks at the particular considerations one might have if there is to be financial investment from somebody in the private sector. We understand, of course, that in some cases that may well be essential. It is likely that one will be looking at the development agreement because, of course, any conditions, for example, that are built into that agreement may well be relevant to the overall financial viability of the scheme. One would recommend looking at the wording of the agreement and making sure that it is consistent with the acquiring authority's wider public duties and powers. So although there may be points that a private developer would want to put in there to secure their interests, the acquiring authority is going to be looking at the public interest and will have certain duties and powers that they can't tie their hands with regard to. A good relationship with that private sector developer and the acquiring authority is going to be very important. It is likely that a large scheme is going to take years to conclude, and therefore maintaining a good relationship will be very important. The development agreement itself may need to be enforced, and therefore giving consideration as to how that might be done and in what circumstances is going to be important. It's always better to consider that earlier in the day rather than later. And of course, ultimately, if the worst comes to the worst, what will happen if that development agreement falls through? Will there be any options, for example, given to the acquiring authority?
Yes, and I think it's important to remember in all of this that compulsory purchase orders more or less invariably are required to be confirmed. And the confirming body may be the body which makes the order itself if there are no objections. Otherwise, ordinarily, it goes off to the Secretary of State, who will say that there should be some sort of inquiry into it. So one can't, so to speak, expect to get by on minimal documents or documents which don't actually form the functions or necessary functions which are sought, because, as is said there, the development agreement will come to be revealed come what may, and you're likely to get people chewing over it in some degree of detail to see, will this actually work? So be careful about these matters and always think in preparing them, to my mind, always think, even if you think we're going to get by without any objections, how would this look at an inquiry?
The next section deals with time and cost, which is described on the basis of might be considerations that one has if there are objections and difficulty perhaps with the existing compulsory purchase process. This slide deals with the circumstances in which objections might be made, which I'm sure will be familiar to everybody. The point really being made is that if objections are made and are outstanding, i.e. not resolved relatively swiftly by the acquiring authority, then it's likely they're going to lead to a public open inquiry, and of course that will lead to additional time and resources for the acquiring authority. Is there anything else you wanted to add to that?
No, I just add this, if I may, as far as that is concerned, on the time and cost aspect. One aspect of a compulsory purchase order is ensuring that you know what are the interests in the land that you are going to acquire or want to acquire, and who has got those interests. And so work undertaken early on to determine those matters is never going to be wasted work, because whoever does it is able throughout the process to use the material derived, who owns and what are the interests, to endeavour to overcome objections by the simple expedient of buying the land in advance of the inquiry, if there's going to be an inquiry, for example.
The first question we asked is whether objections might be accommodated, and this is a means of perhaps minimising the time and cost implications arising from objections. Although there are some key points to bear in mind, it is of course going to be beneficial for an acquiring authority to reduce the number of objectors remaining. If an objection can't be addressed without prejudicing the scheme, can be addressed without prejudicing the scheme, and then it may be possible to consider accommodating the objection in some way. But it should be borne in mind that if the scheme is to be amended, then that would have to be notified to the Secretary of State, and it would be for the Secretary of State to decide whether or not that amendment should actually be made.
I think once again it can be added to all this that knowing exactly what you're doing and who you're dealing with and the interests that you want to acquire is obviously important. I'm assuming that one's proceeding on the basis that one wants to make and then implement the order. And in that circumstance, whatever the order is, the way in which the objections come to be accommodated, if they can be, either by purchasing the land in question or by making some slight modification, if necessary, one can think about the sequence in which that should be done, so that you can get left at an inquiry, if objections have come forward, the circumstance where you've only got one or two left at that inquiry who are in the middle of the scheme and who therefore appear absolutely clearly to be holding the whole thing up, whereas the ones at either end might have been more difficult to deal with. So choose who you're going to go for first in terms of getting shot of objections, and then work accordingly.
Following on from that, one may consider whether the land could be purchased by agreement rather than compulsorily. As a general principle, because the CPO is intended to be a last resort under the guidance, endeavour should be made to purchase the land by agreement in any event, but doing so has three particular advantages for the acquiring authority. First of all, quite evidently, it might preclude the need for a very long and costly CPO process. If the attempts to acquire the land don't succeed, that's going to be good evidence to satisfy the Secretary of State that actually you do need a CPO and it's necessary. And the point that Tim's just made, I think, is that if most landowners do agree to sell, then it can make those holding out look less reasonable, and that's going to be good for the acquiring authority if it does get to an inquiry.
That is absolutely the position, and I have vivid recollections of compulsory purchase inquiries when it's become apparent that those who are holding out are really just being awkward rather than maintaining sensible objections. And so I think that serves to highlight the advantage of trying to deal with matters at a reasonably early stage, so you get agreement and you do view the CPO as a last resort.
When considering whether to purchase land by agreement, it's worth noting that a commercial view can be taken. The guidance specifically permits all costs associated with the CPO to be considered, and it makes specific reference to, for example, legal fees that might be incurred, the staff resources of the acquiring authority, and the costs consequent on a delay when you're assessing an appropriate sum that might be paid for land. But it should be borne in mind that land can't be acquired at any cost. It's not simply a question of paying off any amount of ransom. Public bodies in particular are likely to owe fiduciary duties to their ratepayers, and one wouldn't want to be in a situation on behalf of an acquiring authority where that was called into question. If there is a third-party developer involved, for example, if that's a source of private funding, and if the acquiring authority has entered into an agreement such that the developer are going to be the ones leading negotiations, then their role should be made clear so that whoever is the landowner that might have that land purchased, they should be clear as to who they're dealing with and exactly on what terms they are being asked to negotiate. But by way of timing, negotiations may well be undertaken in parallel to the CPO process, and that's anticipated in the guidance from the relevant department. If the public inquiry is imminent, however, it may be found that landowners are more inclined to enter into meaningful discussions, and that will again point to the interest in narrowing down the number of people that are outstanding by the time we get to any inquiry.
Just to pick up on a point about land can't be acquired at any cost, and that's absolutely right, of course, and you've got to bear in mind the fiduciary duties owed, because the local authority can't just go around splashing money, even assuming it had money to splash. But you can also bear in mind, strange as it may sound sometimes, that some land, it can be quite cheap. And I can remember vividly acquiring compulsorily for, down in Bristol, a large cemetery where we had to look at the costs associated with developing a cemetery, which are really huge, leading to the proposition that this cemetery came to be worth about £10 in total, rather than the hundreds of millions that some hopeful owner said it was worth on the basis of the fact that he wanted to build a whole load of houses upon it, which he was unlikely to be able to do because of the dead bodies that constituted the cemetery and the graveyards and so forth. So just bear that in mind, because practically it can be surprising how some land requires a great deal to be spent upon it before it can be developed. Bristol, I should say, wanted to acquire the cemetery so that the public could continue to use it and enjoy it as a park.
The next topic is the final one we highlighted to begin with, which is the public sector equality duty. As you'll know, that's under Section 149 of the Equality Act 2010. It's a particularly relevant consideration where there are concerns about gentrification, for example, which has been quite a hot topic in central London in recent years. But it's important to remember the particular wording of Section 149. The public sector equality duty only requires due regard to be given to the various considerations that are set out. It isn't a duty to secure a particular result, for example. The acquiring authorities need to complete an equality impact assessment in order to adequately or clearly fulfil that requirement. I'll move on to the next slide swiftly, if I may. because that makes a few points that might be in mind for practical reasons, which is that it's likely to be a good idea for the public sector equality duty to be taken into account when formulating the reasons for making a CPO. And indeed, a statement of case for a public inquiry is also likely to benefit from bearing it in mind. It has been made clear in recent case law that potential claimants should bring information relevant to the duty, or indeed associated factors such as obligations under the and rights under the Article 8 of the UCHR, to the attention of the inquiring authority early in the process. And if they don't do that, it's more difficult for them to argue that the duty has been breached. Because of course, if you don't have the benefit of having something brought to your attention, it's difficult to criticise if you're not weighing it in the balance and giving due regard to it. It's also worth highlighting the principle in the case of Durdana, which was applied in a planning context in the case of Foley, which is that even if the duty is found to have been breached in some way, is it highly likely that the outcome would have been the same without a breach of public sector equality duty? And if it is likely that it would have been the same, and that's likely to be helpful for the acquiring authority in saying that really it shouldn't make a difference, therefore, and there shouldn't be any relief.
I think if I can add to this exercise on public sector equality duty, it's plainly important, and the preceding slide said you're likely to want to have an equality impact assessment. I would say probably you're more or less certain to want to have such an impact assessment, but that shouldn't be too difficult an exercise if you focused your attention and keep focusing your attention upon the fact that you've got to have a compelling case in the public interest, because the public interest extends very broadly and embraces more than those people, to pick up on the recent circumstances where there's been concern about this, picks up more than those people who are merely those who are going to be gentrified, if people can be gentrified rather than places. And you need to therefore think broadly, where is the public interest in all this? Is the public interest extending beyond this small group of people who are going to get these gentrified roads? Does it go beyond that? Does the public interest cover a range of aspects? And if so, you're likely to be picking up and covering your equality impact assessment as well. So I think start always with the public interest, bring into play definitely the public sector equality duty. But if you're considering the public interest well and extensively, you're likely to be picking up on public sector equality duty obligations at the same time. I think that would be fair to say, wouldn't it, Vivienne?
Yes, I think so.
Yeah.
The next slide, I think, picks up on some points related to the same topic, which is that for obvious reasons, challenges or potential challenges relying on public sector equality duty should be taken seriously. There was a scheme considered back in 2016 that you may remember in Suffolk, where the Secretary of State, which I think was Sajid Javid at the time, refused to confirm the compulsory purchase order. And multiple reasons were given for that, but they did include the impact on, for example, elderly residents, children and Black and minority ethnic residents. There was a particular concern that people who were being bought out of their interest in the land wouldn't have sufficient funds as a result of that to relocate to comparable property, for example, without having to go very far away. But it's worth bearing in mind also that the scheme was ultimately confirmed, the compulsory purchase order was ultimately confirmed in November 2018. So it was perhaps a hiccup along the way, but no doubt something worthy of consideration. Related to Tim's point about the usefulness of the equality impact assessment, if you do have an equality impact assessment, that's held to be usually convincing evidence that the public sector equality duty has been complied with. So prima facie, it looks quite good for an acquiring authority if they've done one. It's not necessary to identify or consider all possible impacts on equalities. as part of an equality impact assessment, and a relatively broad brush approach is acceptable. So if somebody comes along and says the acquiring authority here hasn't considered such and such factor, that isn't necessarily fatal, and it doesn't necessarily follow that there's been a breach of the public sector equality duty. But it's likely to be a good idea to bear that in mind if it's brought ahead of a proposal or ahead of a CPO being made. And it should always be borne in mind, of course, that objections along these lines, even if they're unlikely to be successful overall, can still generate quite a lot of pressure and quite a lot of delay and additional cost associated with that. And so it may be desirable to engage and address it, even if actually the public sector equality duty itself doesn't secure that a particular outcome should be obtained.
I think all those points are absolutely worth having in mind. It's really important to make sure one's covered this off. And it really is a situation where you have to have a kind of checklist if you're running a compulsory purchase order and that you've done these things, because you can't expect these matters to pass through lightly. Vivienne mentioned earlier, which is completely true, that compelling a case in the public interest is not something which finds expression in section such and such of such an act or anything of that sort. However, that sort of language would undoubtedly find resonance in the courts, because the courts have always viewed taking someone else's property as a very serious step to be done. And constitutionally, they view that as very important. And it's only to be done if there's good justification for it. And so that guidance, compelling case in the public interest, has a relationship with the way in which the courts approach any question of appropriation of property, which is what compulsory purchase is. And they recognize that this is how it must be seen. So that is, I think, the headline to take away from all these matters, the compelling case in the public interest. To answer the question put at the beginning as to why is it the case, or is there a reluctance to make use of it? I think the answer to that overall question is there probably is a reluctance to make use of it. The first reason why there's a reluctance to make use of it is because public bodies who have the powers of compulsion are often strapped for cash and therefore would find it difficult to come up with the necessary finances in order to carry through compulsory purchase. And secondly, I think there's an apprehension which leads to a reluctance to make use of it on the basis that it all can be terribly complicated with lots of risks involved. Now, it's undoubtedly true that there are complications, but if you take enough time and set those out clearly enough and get your guidelines in place clearly enough, you're likely to be able to get that through, but you have to be prepared to devote a considerable amount of work to the whole exercise. It's not a small job, a compulsory purchase order, save and excepting, of course, those individual cases which might arise where one particular house might be needed or something of that sort to finish something off. But anything of any decent size is going to take time. I think that's fair, is it, Vivienne?
Yeah, I think so.
Now, what I don't know, I think we've reached the end of the slides. What I don't know is whether we've got any questions in the chat box. As I say, these are matters where points can crop up. But generally speaking, if you want to embark seriously upon compulsory purchase, you need a time scale, you need a plan, and you need to align yourself with that. And you might also find it useful, especially for a compulsory purchase for planning purposes, which is one of the compulsory purchase powers most frequently used, because if you use it for planning purposes, you might be able to get in a private sector developer to help fund the whole exercise. Bear in mind that it's far easier to say that something is desired for planning purposes, leave aside whether you've got a planning permission or not, if you've got it written into the question of the local plan and the development plan, so it can be seen as part and parcel of what is proposed. A question popped up, I think, but it's gone off the screen now.
Yes, it's a question relating to public open spaces. Are you able to comment on public open space and what needs to be considered in ensuring that the order is confirmed, i.e. if you are not sure if there's any recreation use on the land?
I think the answer to the question is, obviously one can acquire land for public open space, and the power to do that is present. The way forward is in large measure the same as the way that we've just been discussing. If you want to ensure that the land that you're inquiring isn't subject to what I will describe as recreational rights, you've just got to take the necessary steps to ensure that there are no such recreational rights by investigating the circumstances, if necessary, taking some protective measures to prevent recreational rights. But the course, the general course that is to be followed is the same for acquiring land for public open space as it is for acquiring land for any other public purpose.
How is the compulsory purchase process affected by pending planning applications? If a compulsory purchase proposed in connection with road widening, if there is a compulsory purchase process proposed in connection with road widening and there is a pending application for housing on the site, is it reasonable for council to act to delay a planning application determination where it could affect prospective site's value?
No, is the answer to that question. An application for planning permission could be dealt with in the ordinary way. If there's a reason for refusing planning permission because it might prejudice some other proposal which is coming forward, then that stands to act as a reason for refusal. But what it doesn't do is operate to allow the local planning authority to say, this application's just come in. Ordinarily, we would take 12 weeks to deal with it. It's going to be handy for us to take 12 years to deal with it. And therefore, that's what we will take. You can't do that.
There's a further question, which is it realistic for a local planning authority to compulsorily purchase a ransom strip to enable housing delivery on an allocated site where the developer will not negotiate with the landowner? The landowner will pay the cost of the compulsory purchase order. The reason for not negotiating with the owner relates more to protecting the market and electricity supplies. Well,
the answer to that question would appear to be yes. Obviously, one doesn't know the full set of circumstances, but if you're being held up in some planning proposal by X, here the ransom strip, if you're being held up by that, then it seems to me perfectly legitimate to say this is being sought for planning purposes to enable that development to proceed. Therefore, please may we have it by compulsion.
I think that's all.
And the slides can be made available by email if you send in your email address to clerks@4-5.co.uk. But anyway, I hope everybody enjoyed it, if enjoyment is the right word for a talk on compulsory purchase. And thank you all very much for attending, and I hope everybody has a good evening.